We have a lot to talk about today. This is the much anticipated series that will address the new T visa policy changes that went into effect August 28th, 2024. There's a lot of good stuff in there for immigrants that qualify for this special type of relief that not a lot of people know about. So let's get into it. I'm U.S. Immigration Attorney Sharif Apar. I help clients to identify ways that they can empower themselves to get immigration relief, to get the work permit, to get their green card without leaving the United States. And the T visa is very much one of those very important forms of relief that my clients get in order to legally live and work here. Now, before we get into the meat of the matter, let's talk about what the T visa is. If you have been the victim of trafficking here in the United States, you can get the T visa. The T visa enables you to get your 4-year work permit and updated I-94 showing that you now have legal immigration status here. That means that you have permission to live and work here for the next 4 years. But one very important form of relief that my clients get is a pathway to the green card. 3 years after having the T visa, you can apply for your green card. And there are ways to apply for the green card even earlier than the 3 years after getting your T visa. The T visa is also available for relatives of the main applicant of the T visa. Relatives are the spouse of a T visa applicant, the children who are under 21 and unmarried of the T visa applicant. And if the T visa applicant is under 21, it also covers the parent of the T visa applicant and any minor siblings of the T visa applicant who are under 18 and unmarried. As you can see, the benefit of this is invaluable to someone who has endured or been subjected to trafficking. Now, let me note here that under immigration law, trafficking is defined very broadly. So get out of your heads the stereotypical ways that you have seen trafficking. So I want you to be able to open up your minds and absorb the broad definitions of what trafficking is. Before I got into practicing immigration law and helping my clients to get the T visa, I too thought of trafficking in the stereotypical way. I thought trafficking involved physically forcing someone to comply in order for them to perform labor or sexual acts. And when I say physically forced, I mean that they were physically harmed or physically restrained and forced into submission. However, the acts of the trafficker to get an individual to do labor against their will or to perform sex acts against their will is much more broadly defined than just physical force. And this is what the policy manual also addressed. So we're going to get into detail about the terminologies that have now been included in the policy manual to make clear the kinds of behaviors that are involved in forcing someone or making someone feel as if they have to perform certain labor or sexual acts. So they have addressed certain terminologies to make it more immigrant friendly and also to clear up any kind of vague language or to clarify what they really mean using more specific terminology. For instance, instead of using the word alien, they're now using more humane language, such as victim, applicant, and non-citizen. They have included terminology that's more gender neutral, so that there is not the impression that victims of trafficking are only women or only men, but encompasses all genders. And no matter how the applicant identifies, they can still be the victim of trafficking. Under the new regulations, they have made very clear that they are still keeping the standard of any credible evidence. So the T visa applicant has to show evidence that it is more likely than not that they were the victim of trafficking by presenting any credible evidence. That means any believable evidence. I often get this question, and this is, I don't have any proof. How can I get the T visa without any evidence? But this is what makes it a lot easier for victims of trafficking to come forth and to present what they have in order to get this relief. Now, any credible evidence even means their declaration. That means even the memories that you hold in your head can be put to paper in the form of a declaration that then turns into any credible evidence. So to start, the Immigration Service has addressed the definition of commercial sex act. Commercial sex act means any sex act on account of which anything of value is given to or received by any person. The Immigration Service has specified what anything of value means here. It is interpreted very broadly to include things other than just money or financial gain. Instead, anything of value could mean a commercial sex act done in exchange for safety, protection, housing, immigration status, work authorization, or continued employment. Now, let me give you an example. When I represent my clients in these sorts of scenarios, for example, a client came on an H-2B visa. When they came on the H-2B visa, they were told by the manager that if they did not comply with their request for a sex act, that they would no longer renew their H-2B visa for continued employment. This proposal forced my client into performing a sex act in order to secure that thing of value to them, which was their visa and their continued employment. This is sex trafficking. So let's talk about the definition of labor trafficking and how the Immigration Service has made moves to further define certain aspects of the definition of labor trafficking. Labor trafficking is the recruiting, the harboring, the transporting, the provision, the obtaining of a person for the purpose of subjecting the victim to involuntary servitude, peonage, debt bondage, slavery, through the use of force, coercion, or fraud. Now, in the policy manual, the USCIS has further expanded upon the definition of coercion. What exactly does coercion mean in the context of labor trafficking? So a part of coercion may be threats of serious harm and abuse or threatened abuse of legal process. So if an employer, a relative, anybody threatens serious harm or uses the legal process or threatens to use the legal process in order to force someone into involuntary servitude, that could be a form of labor trafficking. The Immigration Service has made it very clear that they will evaluate serious harm broadly to take into consideration the surrounding circumstances, including threats to the immigrant's reputation, which includes financial and reputational harm. So serious harm does not just mean a fear of being physically harmed, but it could also mean a fear of being harmed in a way that does not necessarily mean physical harm, but financial as well as reputational harm. For example, if you were working as a nanny and one of the tactics that your employer used to keep you to comply with their demands, even though you did not want to go with those demands, is they said they will get you blacklisted. They will spread the word to other parents or other people who need a nanny that you are not capable of doing the work. In essence, they are threatening your reputation as a nanny. Now, another aspect of coercion involves abuse of legal process or threatened abuse of legal process. Now, they have expanded on this definition by making it clear that they could also threaten civil action against you, not just criminal actions. For example, if the employer makes a threat against you that they will take you to court and sue you in order to get back your wages if you leave the job or if you don't comply with them, that is an abuse of legal process or a threatened abuse of legal process in order to get you to continue working or to continue to comply with their demands. Here are some more examples of serious harm. Fear of serious harm under the definition of coercion could be threats to even your relatives and third parties that are close to you, banishment, starvation, bankruptcy, being subjected to isolation, denial of sleep, and other types of punishment and forms of retaliation, refusing to send money to family abroad, withholding pay that does include late payments of wages, and also withholding other forms of compensation that you're entitled to. And withholding of pay and withholding compensation also can lead to other problems, like your inability to pay for debts, your inability to cover your medical expenses, as well as to fulfill your nutritional needs. Threats of serious harm does also mean threats to get you deported. And reputational harm, as I said before, can cover situations where you are told that they will blacklist you so that other families won't hire you or other employers will not hire you. Another example of reputational harm are threats to say that they will accuse you of theft, and based on the accusations of theft, you're unable to find other work because your character has been harmed. Now, here are some examples of abuse of legal process. So if an employer claims that they have to pay you a certain amount because it is mandated by the law, that is an example of a threat of legal process. If an employer also uses the legal process to threaten imprisonment or institutionalization, that is also an example of abuse of legal process. If you're in a situation where you want to leave, for example, you may be on an H-2B visa and you want to leave before your contract ends because you've realized that they're violating the terms of your visa and you want to get out. But they now tell you that if you leave, they are going to terminate your visa, report you to ICE, and have you deported. That is abuse of legal process. Now, keep in mind that the involvement or investigation of law enforcement is not a requirement in order to get the T visa. Now, where law enforcement is involved, they have expanded the types of law enforcement agencies that can be involved. Now, some of these are the Adult Protective Services Agency, and authority that is involved in not only law enforcement like agencies such as the police, but also in civil agencies as well, administrative agencies, and agencies under tribal laws. Some of these types of agencies does involve civil agencies like the EEOC, which is the Equal Employment Opportunity Commission, National Labor Relations Board, offices of the Inspector General, Bureau of Indian Affairs, and offices for civil rights and civil liberties. Now, immigration has made it very clear that they do not require these agencies to show that they have started an investigation or that they've done any kind of prosecutions in order for the applicant to get the T visa. Immigration judges and ICE attorneys may also submit certifications supporting the application of the T visa applicant. But keep in mind, it is not a requirement. Now, here's the highlight of this series. The USCIS has now implemented a new policy that will enable applicants to get their work permit while they wait for the T visa approval. That was not the case previously, but now it is. Now, the Immigration Service will start with what's called a bona fide determination process. Applications submitted after August 28, 2024 are going to go through a preliminary review. The Immigration Service will review it to ensure that the application is bona fide. The way they're going to determine whether the application is bona fide is by looking at three things. Has the applicant submitted a complete application with all the necessary evidence? Have they included their signed personal statement? And have they completed the background check, usually done through the biometrics fingerprinting appointment? If all three of these requirements are met, they will determine that the applicant has submitted a bona fide application and provide a bona fide determination letter, which will allow the applicant to get a work permit, to get the work permit if they've already applied for it, or to submit an application for the work permit so that they are able to get the work permit based on the bona fide determination letter while they wait for the final approval. They will also do this bona fide determination for any derivatives that apply with the main applicant. That means derivatives means the spouse, children, parents, siblings of the main applicant. They're going to look at 4 factors to determine whether the derivative can get the bona fide determination letter and the work permit while they wait for the final decision. To make a bona fide determination, they're going to look at whether the derivative is in the United States, whether the derivative has a complete and proper application on their behalf, whether there's evidence attached to the application that shows that they do indeed qualify as the relative of the main applicant, and they have a clean background check. Now, based on this, the USCIS is now accepting new applications for the work permit based on a new category called the C40 category. Every I-765 application for the work permit that's submitted has to be assigned a category. And in this case, once the USCIS identifies the C40 category, it means that they will issue the work permit based on the bona fide determination once that has been approved. The way that we are doing this right now, we are submitting the entire application packet along with the work permit application with the category C40 to ensure an expeditious process where our clients will be able to get the work permit right after a bona fide determination has been made. Now, I know the next question is, well, what about those who applied before August 28th, 2024? Now, those who have pending applications already will still go through a final determination process. And if immigration finds that they need additional information, they're going to issue a request for evidence and then conduct a bona fide review to determine whether they will issue a bona fide determination while they wait for the response to the request for evidence. Keep in mind that when they're doing the bona fide determination review, they will not necessarily withhold the bona fide determination based on inadmissibilities, just as long as the main applicant and the derivatives do not present a danger to public safety or national security. Now, usually, an applicant has to show that they're physically present in the United States on account of the trafficking. The Immigration Service has clarified this by breaking it down into 5 requirements. The applicant must show that they are currently being subjected to trafficking. they were freed from the trafficking by a law enforcement agency. They can also show that they escaped before any kind of law enforcement agency, like the Department of Labor, was involved in the process. That at any point in the past, they were subjected to a form of trafficking. They may not necessarily be facing that trafficking now, but their presence in the United States is still related to the trafficking in the past. For example, my clients have been here for years after the trafficking occurred, but they remained in the United States because they did not have the ability to leave the United States after the trafficking. They may not have had the financial resources available to be able to leave the country to go back home. And so that in itself could be related to the trafficking. That's why they continue to have physical presence on account of the trafficking. Other examples are they may have developed injuries or medical conditions that were related to the trafficking and have to continue to be in the United States to get medical care after the trafficking occurred. And even if they left the United States, they can also show that they returned to the United States with a valid entry in order to cooperate or participate in a process, whether it's judicial, a civil, or administrative process regarding or related to the trafficking. What if you left the United States and it was only after you left the United States that you started to realize that you were the victim of trafficking and you want to be able to get relief because of the trafficking that occurred? The Immigration Service has stated that they will not necessarily deny your application based on you leaving the United States after the trafficking if you can show the following. You left the United States, but you re-entered, and that re-entry was related to your continued victimization or the continued trafficking. You left the trafficking, but upon your return, you have now been the victim of a new instance of trafficking. You were provided legal entry in the United States to participate in a judicial, administrative, criminal, or civil process that's related to the trafficking. The applicant is now present in the United States because they are now participating in a process related to the trafficking. For example, if you left the United States, but then you were called up by the Department of Labor and told that you are now being paid damages because of a past investigation that occurred, and you return to the United States to be able to take advantage of the relief that the Department of Labor is granting to you, that can also be a way to get around your departure from the United States and still be approved for the T visa. And also, if you return to the United States to get services such as counseling or any other forms of relief related to your victimization, then that can also mean that they will not use your departure against you. Now, keep in mind that continued victimization does not necessarily mean that you were trafficked when you return to the United States. It could also include a situation where you fled and entered the United States again because you feared that you would be trafficked in your country. Now, keep in mind that we have a lot of experience and we represent clients that have been the victims of trafficking even more than 30 years ago. And we've gotten these approvals. The USCIS has made very clear that you can still get this relief no matter how far in the past you were the victim of this form of trafficking. Another thing that the Immigration Service has acknowledged is that the delay in applying for the T visa may be years as a result of lack of support of the victims, the trauma, lack of access to legal representation, and even the lack of knowledge that they're victims of trafficking. In many cases, I talk to my clients And that is when we realize that they have been the victim of trafficking. Because before that, they were not very educated on what the definition of trafficking was. And if they were not knowledgeable about what the definition of trafficking was, they surely did not know that they qualified for this T visa. So physical presence can take into account the delay as a result of these factors. Another big change here is that the applicant can now show not only an extreme hardship to themselves, but an extreme hardship to a third party. It also takes into account economic hardships as well. Now, here are some further clarifications about who qualifies as derivatives of a T visa applicant. Now, if you get married while your T visa is pending, your spouse can still apply as a T visa applicant derivative as well. Stepchildren and step-parents can qualify as derivatives as long as the applicant applies for this application and applies for the derivatives application before the derivative, that's the derivative child, turns 21. They are going to benefit from the age-out protections. That means as long as the application is submitted before their age 21, they will still be considered a valid derivative applicant for immigration purposes. This does apply to parents as well as siblings of the derivative as well. That means that as long as the main applicant applies for their parent and their siblings who are under 18 and unmarried before they turn 21, that parent or sibling will be protected by the age-out provisions. Now, finally, I'm sure you all will be pleased with this as much as I am. The USCIS has made very clear that it is not their policy to refer applicants to immigration court for deportation or to issue a notice to appear in court for deportation if they're denied. This is one of the most common questions that I get. The USCIS has stated, the USCIS does not have a policy to refer applicants for T non-immigrant status for removal proceedings absent serious aggravating circumstances, such as the existence of an egregious criminal history, a threat of national security, or where the applicant is complicit in the trafficking. These are all the changes that I have covered for you today. Now, what you need to do is make sure that if you have been in a situation where you were subjected to trafficking, that means you were lied to or you were coerced, you were threatened into complying with an employer in order to do work or to perform sex acts, you can give us a call. We take the stress off of your hands to move you through the process and to get you to success so that you can stay here, live and work here, and eventually become a permanent resident here. Give us a call. Let's talk. Until next time, take care.